Hi, my name is Andy Clark, Eugene, Oregon. What you're going to hear is a family court, they call it, hearing. For after many, many years of a guardian of a retarded adult offspring of mine, they just suddenly took it away. You're going to hear there was no reason given. You're going to hear I didn't object to not having the guardianship, but as guardian I needed a reason and didn't get it. That happened in 24 days. Fellow Americans, as they would say, it takes 24 days to snatch your children by the state. I've never done anything wrong. I've been paying the ex-wife $5,500 a month. There was no reason for what they did. I think it's tied to the Wells Fargo matter, only because it seems very coincidental and timing after all these years. You make your decisions after hearing this amazing audio of a child being taken through process. I'm going to hear my house being taken through process. It's been a great year. Thank you, Andy Clark.
Thank you for waiting. This is the time set in the matter of the guardianship of Andrew Justin Clark, 5103-20894. What was submitted to the court was a motion to remove one of the co-guardians, and an objection to that motion was filed. I have reviewed both of those documents. I appointed Mr. Gaydos to represent the protected person, and now we are here. I also asked the court visitor to submit a report. Ms. Villigren, if you want to have a seat up here in the jury box so you can hear what is going on. Any opening statement for the petitioner?
Very briefly, Your Honor, it's our intention, it's my intention to call Ms. Clark, but to limit her initial testimony to just affirming her affidavit. It's not entirely clear what Mr. Clark's objections are from his affidavit, so to some extent we are anxious to hear what his objection to the motion is. But as a general matter, it's our position that Mr. Clark hasn't, he didn't file any reports for 3 years, that he's always filed late ones, but more importantly, he doesn't have any contact with the protected person, with A.J. Clark, and A.J. doesn't desire to have any contact with him, and especially because of A.J. Clark's special needs, anything that disrupts his stability and security, which contact with Mr. Clark would have, would not be good for him. And he's made a tremendous amount of progress during the time the guardianship has been established. So that, and to prevent any conflicts between
objection, Your Honor.
No, this is an opening statement.
Thank you.
For those reasons, we're asking for Mr. Clark to be removed.
Mr. Gaydos, your client's position?
Your Honor, in my conversations with my client, Mr. Bruce Newton, actually stated it accurately. I've had 2 conversations, and he has no desire to have contact with the co-guardian.
Okay. Mr. Clark, since you are the objector, what I thought I would do, you are objecting, instead of making you say this twice, one of which in an opening statement and also your objections, why don't you begin with your testimony so that this court can take your testimony with regard to your objections.
Thank you, Your Honor.
All right, so I'm going to ask you to come forward to be sworn in, and then you'll come up here.
Thank you.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth?
Yes, ma'am, it is. Yes,
You may be seated.
thank you, ma'am. I'm going to grab my glasses. That's okay.
You may.
Okay, so just kind of talk. And if anybody has any
First,
questions.
you're going to state your full name and spell your last name for the record.
Andrew Glenn Clark, C-L-A-R-K.
All right. Now you may please tell the court what your objections are to this motion.
First of all, let me state I'm not objecting per se to the removal of the guardianship. I think I made that clear. A guardian, there's nothing in the guardian contract.
Wait just a second, then, before you proceed. What you stated is, the question is, do you object to your not being a co-guardian?
Yes, I do object, and the reason I object is because as a guardian, I don't see anything in the contract that specifies that I have to see them a certain amount of time,
And as Mr. Newton said in his opening argument, in fact, it wasn't positive or wasn't a good thing for Andrew's stability if I did see him. Now let the record also reflect that Jasmine, is it okay if I call you Jasmine?
No, it's not. This is a formal proceeding.
What's your last name again? Villagran? Ms. Villagran, thank you for pointing that, and I appreciate your clarifying that rule. Thank you. You'd written up a report, and so it presented a fairly positive view of a situation. Now, in addition, I saw a report of Mr. Bromley, Matt Bromley, and that painted a fairly positive picture. I didn't see any prevailing need. I didn't see anything in the documentation whatsoever that said, as guardian of Andrew Clark, I wasn't doing my job. Now, when you turn around and add to the fact that there's been very significant support payments paid, then that indicates to me that I paid for this. Whatever it is that you wrote down, whatever it is that everybody's written down, I paid for. Okay, now, furthermore, I was with Andrew 20 years of his life every single day. I was forced, well, another story, but I actually slept in the same bedroom as him. There wasn't a day in 20 years I wasn't with him actively participating. I taught him how to ride a bike, everything, every day. Now, in Mr. Matt Bromley's report, it says that it's the only, here, I got my notes right here. Sorry about this. It says here, I'm sorry here. Amy Clark is the only involved parent he has known. That's from Matt Bromley. Okay, Amy Clark is the only involved parent he's known. Now, again, after 20 years of raising a child, you know, from the time he was born, being there when he was delivered, you know, that's somewhat hurtful on a human basis. I've got to tell you that. I've got to let you know that's hurtful on a human basis to be told. Now, in addition, it's to my knowledge that Mr. Bromley, who's your partner, set up these trusts, and they're rather significant. Okay, they're rather significant trusts.
Mr. Clark.
Yes, sir. Or ma'am. Yes, Your Honor.
You're not talking to any of those people truly. You're talking to the court because
Yes.
I'm the person that needs to be convinced here.
Okay. Again, in summary, I'm going to summarize and then back up a little bit. We have a guardianship that was arranged prior to a dissolution of marriage. Every last aspect of this marital settlement agreement has been endlessly litigated. I think Her Honor's been on a couple of those. I've had to run through very extensive legal processes just to see my daughter for a few hours. Now, once that happens early on in the game, you realize, wait, this is hard. This isn't working. Okay, even though I had a right to see him, it's not working. And just as Mr. Newton pointed out, when it's that contentious, it actually destabilizes them. Okay, so a guardian then, to be a good guardian, you have to say, well, gosh, if I'm there and it's somehow, as Mr. Newton said, interfering with their progress, then the role of a guardian is to step aside, keep the money going, not object to what the other guardian's doing. You see, so I did my guardian role. I didn't object to it, I didn't interfere, and I stepped back and let it go. That was hard. That was hurtful to me. It was painful to me, but I did it because it was the greater good. That's why I did it, okay? It wasn't that I didn't want to see my children. It was the greater good. It was made so hard and so expensive and so obviously destructive on them, as Mr. Newton has said, that as guardian, the only thing I could do to be a good guardian is to say, you know, it's disrupting the kids, so even if I'm hurt because I'm paying and I don't see, and now they're estranged, I have to accept that for the greater good, okay, and I do. Then the day comes out the sudden blue with no predicate, never a mention ever, never a letter, never a phone call. What do I get? Legal papers in the mail. Legal papers. Okay, abusive process in my opinion. As guardian, anybody could have said, hey Andy, you know, maybe things have changed. Would you want to come on in and talk about this? This didn't happen. It didn't happen. Okay, then they start a process that I'm not really involved in, involving court visitors whose testimony I don't see as real relevant. You know, I really don't. I mean, My understanding is you're basically from a Catholic organization, so that's a violation of my First Amendment rights to include absolutely anything that comes from a nonprofit religion. If I'm not mistaken, you work for Peace Health, but I may be mistaken. I'm seeing the fact that these trusts, the fact that Matt Bromley has been taking care of the kids, what you've all described in all your write-ups is an unlicensed adult foster care where she is very rarely around. Matt Bromley's maybe around. That's what's been described. I'd like you to read it, Your Honor, and correct me if I'm wrong on Mr. Bromley, Matt Bromley's write-up. Now, when you add this to the 1998 charge or legal misconduct against your partner, and then the 2006 allegations of trust violations, it causes me as guardian great concern. Why are we all here? Remember, you guys could have, you saw my objections. If you wanted to send me a letter or give me a call, I'm sure I would have been talking to you. Anything y'all wanted, I've been pretty happy about giving you or working it out, but instead it ends up in court where you can get more attorney fees out of me, as it seems like. So the whole point I'm making is I'm here because I'm exercising the guardian duty. I'm asking why. There's no reason. I've done everything right. I've done right. I have an obligation to do right, and I did my obligation to do right. I didn't interfere. I kept the money up as best I could. Liquidated virtually everything I had in order to keep the money up. Huge amounts of money, Your Honor. $5,500 a month is much of the time. And I see no reason after all this time, no reason other than the trust monies or medical procedures that need to be done, like perhaps a vasectomy, which I would not oppose. If someone had asked me, I wouldn't have opposed that. I wouldn't have opposed that. So if that's what it's about, people could have said, hey, Andy, we need to get this done. And I go, by golly, I didn't understand it's the greater good of society to do that. We have to do that. We don't have to, but it's probably a good idea. Now, so if that's what it was, people could have asked me. Okay? Now, otherwise, then it indicates to me it's for her convenience or somehow related to the money. And from what I've seen in these courts so far, when there's two people getting paid money and me without money here, usually that's what it gets down to is these trust assets, and they're significant. Now, I'd like to throw in last that when we were in court a couple years ago, with Your Honor, on the support issue, we had put in, my attorney at the time had put in a subpoena for Matt Bromley. He wouldn't come. We also had spent about 6 months of legal work, expensive to me, and I didn't have it, trying to get from his office, Mr. Newton's office, any detailing of the trusts themselves and how Ms. Clark is able to use the assets for the trust for personal purposes, such as maybe buying a vehicle as long as the child is transported in a vehicle. There's been none of that. So I say, well, I'm the guardian. I don't object to not being the guardian. On the other hand, I'd really like to have a good reason, you guys, not, well, he didn't attend the graduation or whatever. It's because, again, for years, it's been systematic estrangement, systematic from day one. Now, the nice thing is I made sure to document it all, where I attempted to bring up boxes of jelly and make visits and everything, just turned back around on me. So, again, I impose the elimination of the guardian in summary because I don't view it as removal of guardian. It's in proxy for something else, meaning there's something else it's in proxy for. Because, again, I have paid for the nice vision that you all wrote up. Thank you very much. I paid for that. That's where the money came from, okay? I've got Matt Bromley, who's clearly not a disinterested party. He's not. Giving affidavits that posture major things like Amy is the only involved parent he has known. Do you have any idea the level of hurt when I read that one statement? That's perjury. Your partner's son, in my opinion, Matt Bromley, committed perjury in the submission of that statement. That's perjury. That's libel. He defamed me. That's my view of it. And I think, again, in summary, the entire situation screams unlicensed adult foster care operation, no particular training. We have a person I understand who's a law student. Well, law students are pretty busy. Is that correct? Is it correct Matt Bromley was a law student? I'm not sure about that, but my understanding that's a pretty rigorous program. I don't see how he was able to manage three affected people. I don't. You see the concerns that I have as guardian of one of them thus that the other ones were brought in by the court visitor and by Mr. Bromley, Matt Bromley, I believe I have the right now to ask about all of them because they were brought into this court. And the questions I ask is, why are we here? How does it relate to the trust money? And how much of the trust money is going to administrative expenses and other little things that on the surface appear right? Well, again, I tried to get all that information a couple of years ago through the court, but we figured we'd just negotiate the solution so it didn't see the light of day. But now I think it's going to have to see the light of day. In other words, okay, what's this all about, you guys? What are we here for? If you need me to do something, I'm happy to, as I've told you. And I've tried to keep you, Mr. Newton, apprised via email. But what I've noticed is you use my emails against me. Like where I keep you all informed about how I'm trying to work on the insurance, and then you use them against me in court. I try to let you know that, hey, I'm in federal process with the company because I did the right thing. And fortunately, in federal court, it was shown that I did the right thing in a very unusual way. And you, even though you were aware that I was unemployed and in federal process, you decided on a certain day, a very coincidental day, to garnish every nickel in my bank account. You had a hearing on July 8th that, on a first matter that I claim I was never advised of. I've made it to every hearing, you know that. Yet there's this one on July 8th that somehow I wasn't able to attend.
So, Mr. Clark.
Massive
Mr.
corruption
Clark,
of justice is what we got here. Sorry.
You are objecting or are not
I'm
objecting?
objecting. I'm objecting to it on so many levels. I'm objecting.
I want you to listen to my question
Yes, ma'am.
first, though, so don't interrupt. Are you objecting to your being requested to be removed as a co-guardian?
Yes.
Okay. Anything
Without
else that you want to
cause.
say?
Without cause. I need to know why. Not that I didn't go to a graduation or I was a little late on filing a form. I said I didn't file a form. That's incorrect. They were filed late. So once again, I view perjured yourself when you said I didn't file the form and then you corrected it, saying that I filed it late. So it's that type of posturing and pretexting that's been the basis of pretty much all your work since 2005, where me, the defenseless person, comes in honesty, goodwill, trying to do the right thing, and it's systematically used against me. Again, I need to know, I would like to know what the real purpose is. The evidence of why the guardianship should stand is the fact that I'm here, having given money and not seen the children and have no vested interest. So I have no money involved, none whatsoever, and I don't see them. So I have no vested interest. I have none. My only job as guardian is to ask that question. Now, I should also notice under that law that you referenced, I think it was ORS 225-1. I'm not 100% sure on that one. The ORS that was referenced in your filing, it gives the greater responsibility to the guardian in possession. And in this case, the guardian in possession, Amy Clark et al., Matt Bromley, whoever it is, they have the assets and they have the human being. You have the greater duty under the law. Under that same law you quoted, you have the greater duty to explain to the other guardian in business terms. This is a business contract. It's not an emotional contract. It's essentially business. We have something called a guardian contract that was written up a long time ago. It's never been contested. Okay, so it's like a contract in that sense. I've not violated the contract. There's nothing in the contract that talks about going to a graduation. Just the contrary. Paid and made the whole thing work. So as guardian, it's my right and duty and obligation to do right, to ask, what is the real reason? What is being done with the trust money of these persons? How is the trust used to shield her position then when I come in to modify? We asked that 2 years ago. It never came out. With this, I'm asking the court, respectfully requesting the court to see the logic I'm presenting. I come essentially naked, no money, no vested interest, none. I come that way to court. In opposition are attorneys who are paid, whose offices control rather major trusts for these people, whose son is involved, who's an attorney who didn't seem like he would ever have the time to do this kind of work. And the questions that come out of it, that arise from the material submitted by plaintiff et al., indicates the opposite conclusion. It indicates that Andy Clark, defendant, did his job as guardian, even though he didn't see the children, wasn't allowed to, had to go to court to see his daughter for an hour. Yet I'm here saying, you guys, I see something a little fishy with all this. It doesn't make sense. If you all want something from me specific, well, hey, let me know. You know, if we need to get them fixed, let me know. I'll sign it. You know, you see what I'm saying? So I think that's what I've got. I apologize if I've been a little long. I've been a little emotional about this, and I apologize to the court for that. Is there any questions anybody has for me, or what's
Hold on just a minute.
Sorry. And I'm going to have to get some water.
Cross-examination. Any questions, Mr. Newton? Wait, where are you
I
going?
need to get some water, man.
Okay, hold on. Stay there. Let's
I
get some
can't
water.
speak now.
We're going to get some
Thank
water
so
for
much,
you.
ma'am.
All right, Mr. Newton.
Mr. Clark, did I understand you correctly that you agree and believe that it's not a good thing for A.J. Clark's stability for you to have contact with him at this point?
No, I don't agree. I don't agree. I do not agree. It's not what I said. I said that is the compromise, that is the situation that I was forced to accept. That's what I said. That's what I said. As guardian, I didn't like it, but I had to do right. Do you remember that? I said, I have an obligation to do right. And my obligation to do right is once I see that to see these children, even for an hour, results in legal processes, weird scheduling of visits. I then, as guardian, have to say, you know, this isn't in the best interest of those I guard. And even though it's painful to me, very painful to me, as I noted, as you remember me noting, if you don't remember, we'll go through it. It's painful, yet I had to accept it. That's what I said. Now, once you're estranged and you have to accept that, then the next follows.
Okay, now you've got to start to control yourself.
I'm sorry, ma'am.
No. So,
Thank you.
he answered the question and wait for another question.
Thank you.
All right.
In your affidavit, in referring to visits, you said, once that pattern develops, it's no longer in the best interest of the offspring for me to persist.
In this case, it wasn't. In this case, there was such a high degree of emotional instability in Amy in terms of her vigorous, let's use that, vigorous use of the legal system for spite as opposed to negotiation in advance. You realize, well, wait a minute, I'm $5,500 a month or whatever it was that most of the time. I'm buried. I mean, it's everything I can do to get up and try to make this money and know that I'm not making it and know that I'm going to have to liquidate an asset, which you knew I had to do. Okay. You knew it because I told you.
The statement that
so no, no, wrong. Okay, go ahead.
The statement Matt Bromley made that Amy Clark is the only involved parent that Matt Bromley has ever known, that's an accurate statement, is it?
No, but Amy Clark is the only involved parent he has known. That's speaking of Andy Clark, not of Matt Bromley.
So that's the way you interpret that?
No, that's what it says. It's not how I interpreted it. That's what it says.
Okay.
So that's what it says.
The pronoun he refers to you.
To Matt. I don't have the full document. If someone would hand it to me, long story. I had it all ready to go. And
So
if you'd like to, does anybody have a copy, and we'll go read through that more carefully together? I'd be happy to right now. I think that's a good idea, seeing that we're questioning it, Mr. Newton.
Wait just a minute. Listen to the question.
So you did go to court, and on one instance, you requested some parenting times to do some visits with.
Many years ago.
Okay, many years ago, in 2007?
Roughly, yes. Okay. And again, the MSA, the Marital Settlement Agreement, allowed for it. It didn't say that I had to go to court to get it. Let the record reflect that I was in this courtroom with one of the judges where she sat there and argued about my automobile insurance.
Okay, so we're going to stop here for a minute because there is only one issue before this court. It does not have to do with a dissolution. It does not have to do with a custody dispute. It doesn't have to do with a property settlement agreement. This has to do with Andrew Justin Clark, who is no longer a minor and therefore not subject to the dissolution. He is just be quiet and listen. So what has occurred, or the enmity between the parties with regard to a dissolution, is one thing. The question solely before the court is whether or not you should continue as co-guardian in the guardianship, which is not a contract, which is an appointment by this court, and solely by this court, to determine whether or not you should remain as co-guardian or should be removed as co-guardian. Don't confuse a guardianship and a conservatorship. Guardianship has to do with a person. A conservatorship has to do with the estate or money of a person. Potentially there are other avenues of doing that as well, but the only issue before the court concerns a guardianship.
Then I object to the question because it's irrelevant to the guardianship. Next question.
Have you seen, have you had any, personal contact or visits with A.J. Clark since?
Objection, irrelevant to guardianship.
No, you need to answer that question, sir.
Since 2007?
Again, I've been asked, have I, yet on the...
It's a simple yes or no.
The court...
It's a simple yes or no. First answer yes or no.
I choose not to answer that question because it's irrelevant. I believe I have a right. If I don't, and I'm in contempt, please advise me and I will answer it so that I'm not in contempt.
You need to answer the question then.
Okay. Have I seen them? I wasn't allowed to see them because of
Not
the
them.
animosity.
We're just talking about Andrew Justin Clark.
Andrew Justin Clark, I have seen him on the streets riding his bike. I may have seen him just the other day riding a bike. Okay, but again, getting back to the animosity, it's because of the animosity that disallowed it.
Understood.
So the answer is no, but what does that have to do with the guardian? What does seeing have to do with guardianship? I need to understand, is there a relationship between seeing and guarding?
You refer to money that you've contributed. Isn't it true that you haven't contributed any money other than spousal support payments to the care, welfare, maintenance of Andrew Justin Clark?
$5,500 a month goes to Amy until I didn't have the money. Now,
Is that spousal support?
It's labeled spousal support, but without knowing whether the money went into the various trusts that your partner administers.
Well, we'll get to that in a moment, but the question is that...
It's an irrelevant question because what it's called in the court, spousal support, doesn't necessarily mean that's what the money was used for. I find it inconceivable, and I would find it wrongful if a person in this economy were spending $5,500 a month on themselves. And then if it's being saved somewhere, well, then how come this type of thing didn't come up in our last modification hearing? It is related. It all is related.
The reality is the answer is no.
What's that?
You have not contributed.
No, the answer's yes. I contributed the house that she lives in now, Amy, 30923. That was a joint asset awarded in the MSA. Okay, she lives there. That's a form of contribution. You absolutely cannot take away the past. You can't take away the 20 years, and you can't take away the house that she lives in that it was paid for mostly by me. The court can award it. The fact is, Andy Clark, the one who was with the person, Andrew J. Clark, for 20 years, paid for it one time or another. So it is relevant.
Ask the question in a different way.
Okay.
Subsequent to the divorce and assets being divided between you and Ms. Clark, have you used any of your earnings or assets or money from any other source other than payment of spousal support to Andrew J. Clark?
Okay, before you answer that, tell me what the relevance is.
Well,
Thank you.
I'm just, Mr. Clark has referred a couple different times his contribution of money as a reason why he should be remaining as co-guardian. And my point is he hasn't.
He's talking to me now.
Sorry.
He's not talking to you, Mr.
I
Clark.
apologize.
'Cause if you're using that, if that's being utilized as a basis to continue the guardianship, as the connection, I understand what you're saying. All right, go ahead and ask that. Okay. You need to answer the question, sir.
Yes, every month I give whatever money I can, okay, to Amy, and it's well in excess of amounts that a normal mortal in this society needs when they own that house, the one house, free and clear, at least the last I knew. Therefore, in the fact that she's stating in these documents that the children are sometimes at that house, that amounts that I am contributing, which are very substantial, therefore represent a form of support for these adults because the child support isn't applicable in these cases. So it's support by proxy, meaning I'm paying for the scenario that Ms. Villagran and Matt Bromley, they wrote up a very favorable scenario involving houses and bedrooms and all this. Okay, that scenario was paid for mostly by me at one time or another. Now, whether it was awarded in the court or not is irrelevant in this context. Irrelevant. It's the fact that at one time or another, the situation they described was me, and if it hadn't been for my earning power and my financial ability, that picture you painted wouldn't be there. You see, it wouldn't be there. It wouldn't exist. So therefore, money, the $5,500, which is a huge amount of money, way more than I had, by the way, as you know, it did go towards that. So you can play the little games of linguistics, which seems to be what you've been doing since 2005, is playing your little games where you hide on one side and I'm on the other until it's convenient for you to be on the other side. Point being is this, real simple. If anybody has a reason why I shouldn't be the guardian, a guardian is someone who's supposed to be guarding their interests. If I'm mistaken on that, let me know. I'm supposed to be guarding his interests. I'm not trying to take his money. I'm not trying to take his house.
Mr. Clark, you answered the question.
Thank you.
Any other questions?
Yes. While the guardianship has been in effect, what, if anything, have you done to facilitate or help with Andrew? I'll refer to him as AJ.
Sure. No, it's Mr. Clark. What's the formal term that we have to go with in the court? We were told by Her Honor that there's a certain formal.
Respondent.
Huh?
Respondent.
Thank you. Isn't he Andrew Justin Clark?
We
had a directive, so it's going to go both ways. If I have a directive that I have to refer to Ms. Villagran, which I have no opposition to, then we need to make it consistent, Mr. Newton. Remember, this is a court of justice. You're equal, and I'm equal, and we're all equal here. Okay?
We'll refer to him as Andrew Justin Clark.
Thank you. I appreciate that, Mr. Newton.
Have you contributed anything in any way, explain to us if you have, to Andrew Justin Clark, his health care, his training, education, and care of his personal affairs?
Absolutely. I did the most.
Other than payment of
Absolutely.
monthly spousal support.
I did the most important thing a guardian could do under the situation that you have described, where the most important thing a father and a guardian under these situations can do is stand back. That's what I did. That's the major contribution. Anything other than standing back destabilizes the situation, as you have stated and testified. Okay, so my main contribution as guardian was to A, stand back, assuming the other guardian in possession was doing the right thing, and then B, not complain, not say a thing about it. Stand back. That's the way the guardian in possession wants it. I'm into it. Okay, I get it. I don't want to have to go to court. But then C, each time to see him, and then C, here, right here today, with nothing to gain. I don't possess them. I don't have the money. I have nothing to gain. And I'm just asking a very legitimate, honest question. You're wanting to remove a right or it's not a right, it's an obligation. People don't have rights, in my opinion. All we have is obligations to do right. And you're trying to remove my obligation to do right. And I don't see a reason for it. Now, if I was getting paid $500 a month and that was some problem, well, then I'd say, this is taken from Andrew J. Clark, and I'm agreeing that this may not be good. But I have no vested interest in wanting to be on the guardianship. My job is to guard. It's not to be paid to guard. It's not to see him. It's not to babysit him. That's the guardian in possession's job. And so I've done my job by standing back and letting the guardian in possession do the job without interfering because as we've all pretty much covered, that is what stabilizes the family, is if I were to always be there trying to get in or trying to have motions to go see him or whatever. So to answer your question, I did the very biggest, most hardest thing a human can do in this situation, which was stand back and let the guardian in possession do her job until one day I get your legal stuff in absence of a phone call or a letter. Say, hey, Andy, you know, you've been a guardian. We need to get this done or do this. Please sign this. Did that happen? I don't remember seeing that.
Do you know if Andrew Justin Clark has employment right now?
According to Mr. Bromley's, Matt Bromley's narrative, he's working at the ARC part-time. I don't know that for a fact. That to me would be presenting it as hearsay, and I don't believe Matt Bromley's here to be cross-examined, is he? So I think we need to strike anything he wrote because it's against the Fourth Amendment. And the Sixth Amendment, rights to due process. Okay, if I can't, I don't have the right to question him again, so I can't question Matt Bromley. And then furthermore, his affidavit, it's not a specific affidavit he signed. So his input to this court process has no relevance. Ms. Velligren, I didn't see yours as individually notarized either, yet you are here to testify, so I'd have to accept it. Matt Bromley isn't, okay? So his input has no value, none. It's like the last case where the woman wrote up a bunch of stuff and it wasn't accepted by this court. Same stuff. He didn't notarize it. It's not an affidavit, and he's not here to talk about it, so what relevance is it?
In your affidavit, you state that prior to any court determination about this, a full investigation of the situation by the Department of Human Services should be conducted. The question is, do you have any cause, any reason to think that there's any abuse or neglect of Andrew Justin Clark?
Yes, actually I do. Once I got this letter and legal material in absence of a phone call or any other form of communication, then immediately as guardian I had to assume the worst case. Really, in absence of truth, that's what we have to do, is assume the worst. That's the job of a guardian. Okay, I'm here. I'm trying to get an honest answer. I even submitted it to the court saying, hey, here's my questions. You know, you didn't respond to that. Nothing. We're still here. All I've been asking is, you guys, I've done my job the way I see it. I've guarded him. How did I guard him? By letting the situation go and realizing that, hey, you know, he seems like he's in good hands. I see him around on the street. He's not hurting. Yeah, I'm paying a lot of money, but that's okay. Whatever's right. Okay.
So if Ms. Villegran indicates in her report that Andrew Justin Clark is doing very well, that he's doing better and better as time goes by.
Because I helped. I did it. I made Andrew Clark. I was with him for most of his life. Okay, so and then I again created the structure through the money. However it was directed, there it is. If it wasn't for Andy Clark, this Andrew G. Clark, working hard and smart, making lots of money, and I must add one note, Amy Clark's excellent investments. I will always note, Amy Clark is way better than money than I ever was. I will always note that, okay? Way better. That's why I don't object to the money side. She's good with that. I'm not that great with money. I tend to it's not like I spend it. I just don't make the best investment choices.
In your affidavit, you say you have a continued fiduciary interest through that and possible inheritances.
The inheritance is an odd one, but that's not my main point. In that paper, my objection, the affidavit, it is an affidavit. It is possible. Okay, so an affidavit is my statement of known truth. And when I throw the word possible in there, what that does is it's not a fact then. It's an opinion. Okay, it has no relevance in the context of affidavit when you say possible. It's an opinion. It's posturing, kind of like these reports really are with Matt and with Mr. Matt Bromley and Ms. Villegren. It's posturing. It's stating things that are designed to posture or portray or to give an opinion along with the fact of the affidavit. Again, in summary though, saying the same thing. When you're trying to remove my obligation, I need a reason for it, and everything that anybody's put in writing says, hey, whatever way it is, this is a good situation. We don't know where Andy is. We don't care. We don't know what Andy is, what he pays. We don't know any of that. All we know is It's a good situation per the court visitors.
What's your, has been your occupation for the last 20 years or so?
And why is that relevant? I don't believe it is, Mr. Newton. I don't believe that is relevant. I object.
That's sustained.
Okay. Do you have a professional license?
I object to that question as irrelevant.
Your Honor, the relevance is that if the license is revoked or denied to him under the statutes, then he's obligated to report it. And he states, I'm not sure if it's in his affidavit, I think it may be, that he's not able to.
Better read that one
Wait,
carefully,
Mr.
Mr. Newton.
You're not being asked a question right now.
Objection, defaming, and libel.
Mr. Clark.
Objection.
Mr. Clark. You're not being asked a question right now.
Okay.
Have you had a professional license revoked or canceled?
Objection to question.
The objection is overruled. You may answer that question.
Not to my knowledge.
Do you have specific knowledge of the contents of any trusts that set up in favor of Andrew Justin Clark?
No, and again, that's part of the concern as guardian, in absence of a reason to remove guardian, is why is she spending all this money on attorneys to be here if there's no monetary interest? Remember, I'm the one who does not have a monetary interest to be here.
Do you have any reason to believe that Ms. Clark is abusing those
Yes,
trusts?
I do have a reason. I do have a reason. Shall I go through that reason? Do you want me to go through it right now? Can I?
What are your
Let's go
reasons?
specifically through it. Do you recall when we got together, I believe it was in 09 or 08, for a modification with Judge Holland, and we never went to hearing. But I did subpoena through my attorney in Portland, Matt Bromley, to attend a hearing. He never showed. I also had the attorney requesting the trust documents as part of the discovery. They were never provided. Okay, so I've got Matt Bromley, the son of your partner who does trust work, living in the house, who's a law student, who presumably didn't have time to properly necessarily daycare, adult foster care. I've got what I'm reading is an illegal adult foster care facility. And somehow this whole proceeding is about me, Andy, when I'm throwing back at you people horrific evidence, okay, of misconduct, perjury of your partner's son by stating things like he did. He's not even here to testify. Perjury. Absolute abuse of process. And you're picking me, and I haven't even gone to Andy. I haven't heard Andy. There's no reason to remove the guardian. You're making it up through pretexting. You're pretexting a reason with a bunch of unrelated garbage, Mr. Newton. And that's why I bring all these rights up, because when I bring in things like the First Amendment right to be free of religious input from Peace Health, which is a Catholic organization, when I have a right to Fourth and Sixth Amendment to see evidence that relates to say, Andy, you're here for something. You haven't hurt this guy, Andrew J. Clark, Justin Clark. You haven't approached him. You haven't scared him. The real crime is what mental control existed to cause Andrew Justin Clark to feel that way about me. That's just spite, manipulation of mental control by possession. By possession, meaning the one who possesses the human has the sole right to, or not the sole right, but the sole ability to defame, as you're doing, with statements like this. And I'll read it again. Let's see, about the, oh wow, let's see, 20. Amy Clark is the only involved parent he has known. And again, that's speaking of Andrew Justin Clark. It's just wrong. Again, all I've asked is simple. Why is it so important that if you've got a good situation, all your court visitors have painted a good situation, I'm guardian, you would think that any change would then jeopardize the good situation. I ask, how's it going to get better? How's it going to get better?
Is your role as guardian, if you were allowed to continue, just to do nothing, basically, just to be there?
Do nothing? I object. I object to that. Because again, I said I didn't do nothing. I object to that. I think that's a rude question.
So the guardianship role is to step aside.
No, the guardianship role is to guard under the circumstances. I thought I made that clear. Didn't you hear it? It's to guard. It's to say, everything is okay until I see a threat. That's what a guard does. A guard stands there. Any guard, anywhere. They stand there or sit there, and they're alert. Okay, a guard at a bank. Does a guard at a bank go to the vault and count the money? No. What does a guard at a bank do? Guards. Guards. Makes sure the bank is safe in theory. That's what a guard does. Okay, does a guard go visit the chairman of the board? No. The guard guards. Does a guard meet with everybody in the bank? No, not necessarily, usually not. The guard guards. That's what I'm doing. I'm guarding. Guardian is guard. It doesn't mean go up to the house and knock on the door every week or go find an attorney to go beg for an hour for my daughter. That's not what guard means, Mr. Newton. Maybe in your corrupted world that's what it means, but not in mine. Not in my pure world. My pure world of right. Not your corrupted world of moral control, money control, through this process that we see here.
Mr. Clark, you've gone beyond the question.
Thank you.
I have no further questions, Your Honor.
Mr. Gaydos?
I have no questions, Your Honor.
Thank you.
All right, you may step down, sir.
Thank you. And then I just get the witnesses.
On behalf of the protected person, do you have any witnesses that you want to present?
Do not, Your Honor.
On behalf of the other co-guardian, do you have any witnesses you want to present?
No.
I'd like to call some witnesses, if I may.
You may.
I'd like to first of all call Matt Bromley. I understand his material has been submitted to the court for consideration.
Is he, you may call a witness if the witness is here. Is
Well,
that witness here?
No, and his testimony is not affidavit, so is that part of our consideration? Or?
Well,
I need to know the role of Matt Bromley's paperwork if he's not here, because
he doesn't have any paperwork.
Well, I was presented with.
Are you going to let me finish, or are you going to keep interrupting?
I'm sorry.
Because I'll stop talking if you're going to keep interrupting. A court visitor is directed by statute to interview and investigate independently certain persons. They're required by statute to make a court visitor report, which is to include the persons that they've interviewed and statements that they've made, and then to report back to the court. Whether or not you want to, or any person who is part of the proceeding wants to ask questions of any other person, then they would have to bring that person in. It's not required for them to be here if they don't know that they're going to be asked questions. So at this point, if you want to call a witness, you would have to have the witness present.
I'd like to do that.
Okay, then who is here?
Well, how do we subpoena for later hearing Matt Bromley?
Well, I can't give you legal advice, just like I can't give any of the parties legal advice.
Then what I'd like to do is move to postpone until we can get Matt Bromley to a hearing.
That motion is denied. We're in the midst of this hearing. In fact,
Ms. Velligren, please.
all right, Ms. Vilgren, please come forward. And raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth?
I do.
You may be seated. Please state your full name and spell your last name for the record.
Jasmine Villagran, Villagran.
Mr. Clark, you may ask questions.
Thank you very much. Just one question. What is your view as to the job of a guardian?
That witness, she's not as to the job of a guardian?
Or what is, they're wanting to take away my ability to, or my obligation to guard, to be a guardian that was established prior to a dissolution. What is your view of a guardian's job per the law, or is there a law that describes the guardian view or words, you're representing the court with guardianship matters. What I'm asking you to do is quote Oregon revised statute or interpretations that list the mandatory duties of a guardian.
Yeah, I don't have those, and I don't know what they are, so I can't answer
So you're not aware if there's any mandatory duty of a guardian, is that correct? You're not aware, is that correct? There may be some, you're just not aware of them.
Yeah, I don't know them by you know,
Right.
by
Do
memory.
you know that they exist or not? Meaning
Yes, there are statutes.
that statutes that very, very specifically define duties of a guardian, they exist?
I can't answer that. I don't know that. I know that there are statutes around guardianship.
We know there's statutes around guardianship, but what I'm referring to, Ms. Bellegrin, is causes per the law, specifically, either through decided cases or as fact of the law. Specifically, if you didn't go to your daughter's graduation as an example, or if you don't spend this much time with them, you can't be a guardian. Are you aware of any rules like
No.
that? Okay, so you're not aware of any. But there may be some, I'm admitting that. I'm saying that, there may be some, but you're not aware. Two, how long have you been in the social services industry?
In terms of,
Court visitor work.
gosh, I think I've been doing it for a little around 10 years,
10 years?
11 years, something like that.
Do you work at Peace Health? Is that correct?
I do.
Okay, am I correct in saying Peace Health is a nonprofit organization?
You're correct.
Am I correct in saying that it's a subsidiary or part of Sacred Heart?
It is.
Am I correct in saying that that is run as, I'm not going to use the word Catholic hospital, but it's generally viewed as a Catholic hospital?
Yes.
Okay, so you went to a home, and let me see if I've summarized it, correct me if I'm wrong. You're not aware of any specific requirements of a guardian. You work at a hospital, okay? So you're paid pretty well at the hospital. What's your income at the hospital?
My income, my hospital work is separate from my court visitor work.
Okay.
They're not blended in any way, shape, or form.
Okay. How long did you spend at the home of Amy Clark?
An hour and a half, 2 hours, something like that.
What research had you done previously to determine various factors like their exact condition? For example, what condition does Andrew Justin Clark have? What is he diagnosed with?
I think he's got X syndrome, from what I remember.
Okay. What do you know about Fragile X syndrome? Are you familiar with that, or?
When I did the first court visitor report, when there was first application for guardianship, I looked it up and I knew it then. I don't remember it now.
Okay. What was your purpose? I mean, you go up there to do a write-up. What was the purpose? What did they tell you were to go there for?
My purpose as a court visitor is to investigate the petition before me. And in this case, it was for petition to removal of a guardian. And so I went and I met with Amy Clark, with Andrew Justin Clark, and his two siblings, and Matt Bromley.
And what was the relevance of meeting with, say, his two siblings? Why was that relevant?
Because they live in the same home and they're involved. So.
Well, again, though, we were just talking before when I tried to involve them, and they weren't allowed to be involved. So I'm trying to get some consistency as to when you're allowed to use them. Okay, you being the Catholic worker from a Catholic organization. Okay, so again, though, what I'm noting is the following.
No, what's the question, Mr. Clark? This isn't a time for you to testify.
Yes,
Do
the
you
question
have a
is, I'm going to keep going with the questions, okay? Okay, so you don't have any, correct me if I'm wrong, you don't have any specific knowledge, as you answered first, of the exact duties of a guardian, okay? I mean, you can't cite the laws or the cases. Okay, so then what relevance do you consider that your view has in making write-ups that relate to guardianship when you have just told the court that you don't know what the requirements of a guardian are?
I see my role as a court visitor to go out and investigate and to be the eyes of the court. In fact, I use that quite often when I'm meeting with people. and I talk to as many people as I can who are involved and write as well as I can what statements they've made and to present the broadest and best information I can for the court.
Appreciate that. All the parties involved, one would think that the other guardian is an involved party, me. I don't remember hearing from you. Did you give me a call, or did I miss that?
I did. I spoke with you on the phone, and I'm not sure if it was the same day or the next day.
I don't recall, and I apologize. I get a lot of phone calls from people, and I go, by golly, I'm in my house fighting the world here, and I'm getting these calls about this. Come on, you guys. So I appreciate that. Thank you for bringing that up. Okay, so what we have here is we have a document that references other people, mainly Amelia J. and Aaron J.
Mr. Clark, what is your question?
I'm getting to that, Your Honor.
You need to get to it sooner, instead of making statements first and then have your question.
Sorry,
So you need to ask the question.
I have to do what they do. I learn from the attorneys.
Actually, Mr. Clark, that isn't what they do.
That's what I'm seeing. But anyway, Your Honor, sorry. Okay, Ms. Vellegren. Okay, so you're not aware, if I'm getting this correct, of what the role of a guardian is. You go up and wrote up a report. Now, is there anything in the report that said Andrew Clark, Glenn Clark, I'm sorry, is not guarding or is negatively affecting Andrew? I didn't see anything in your report. So is there something in there that says the continuation of Andrew Glenn Clark as guardian will cause the situation I described to either get better if he's removed, or if he's not removed, this situation will get worse? Was there anything in your report to that effect?
No.
Okay, so your report.
What's your next question?
My next question.
Don't repeat what she just said. I heard what she said as well.
Thank you. Appreciate it. I never know. I appreciate it. Okay. Okay, so in terms of, I think that'll do it then.
Any questions, Mr. Bromley?
Newton.
Excuse me, Mr. Newton.
It's okay. Did it appear to you, based on your the interviews you did in 2003 and the ones you just recently did, that Andrew Justin is doing much better than he was then?
Yes.
Objection. Objection, because the 2003 report is not part of this record.
The objection.
And in 2003, he was much younger.
Okay. The objection is overruled. You answered the question. Ask your next question.
I don't have any further questions.
I have no questions, Your Honor.
Cross-examine.
No, this is your witness. You may ask a redirect question.
2003, what did your report state? What was the purpose of your report in 2003?
The purpose of my report was to let the judge know what was going on, that the petitioners had applied for guardianship over Andrew Justin Clark and what the situation was.
And so that was to establish the guardianship?
Mm-hmm.
Okay. And is that right now being presented to this court as documentation of some form to remove guardianship at this point?
I don't know.
It just came up, and the reason I bring it up is because, well, if it's being
Do you have
used...
any questions that you want to ask this witness? Not a statement
Thank
from
you. I appreciate it. I'm sorry, I'm not an attorney. I just don't know all the rules. Yes, I have some more questions. If a guardian is doing the right thing, and the subject, in this case Andrew Justin Clark, is progressing, and as it just was stated, is it logical then to conclude that the guardian is either benign and didn't do anything to hurt the scenario or somehow benefited the scenario? Did you follow what I'm trying to get at here? If I may not have
I'm
answered.
not clear what the question is.
I'm trying to follow the judge's directive and how to ask it, and I apologize for this. But the gist of it again gets down to being, okay, you documented a situation in 2003. There was several years of that where I was, at least two, that I was with Andrew Justin, Clark, every day. Apparently the situation's even better as in 2011. Somehow we've established by default, in the community, our way of having a guardianship. And she's never called me up and said, Andy, I can't have a guardian because of you're not seeing the children. So the question is do you see anything that shows that my guardianship made it so that Andrew Justin Clark didn't progress as fast as he should, or is it being suggested that it would be faster progression if I wasn't the guardian? Are you following the question now? I'm trying to say, what is it that's changed that makes it so I shouldn't be guardian? I'm trying to find that from your report, and I'm not. That's why I'm asking you to point it out to me.
Yeah, I'm not real clear what the real clear question is.
Okay, the real clear question, I'm going to try to clarify it. Do you see any reason I shouldn't continue with guardianship?
In filing my report, I didn't make a recommendation because I really feel that that's a question for the court and not the court visitor.
So as court visitor, your job was to then go and document a situation at that house for an hour and a half. Now, you referred to it as an investigation.
Mm-hmm.
An investigation normally, again, I'm not saying this, but my belief is it's more than an hour and a half visit. It would have been more, maybe getting some medical records, maybe some of these trust documents. In other words, if you're being called up to a house and all the people are involved parties or mentally disabled parties, I'm struggling to see the value of your work, and I'd like you to explain the value of it to the court process. In other words, why is it even relevant to the guardian if you're not aware of what it takes to be a guardian?
I'm not clear what the question is.
Again,
and I'm sorry.
The question is, how do you, Jasmine Villagran, believe that your work as court visitor, apparently mandated by statute, in absence of your knowledge as to what it takes to be a guardian, then why is it relevant? Or how do you see it as relevant? That's what I'm asking. How do you see it as relevant if you don't know what a guardian's job is and you've only met him for an hour and a half?
I believe that the original question you had asked me is if I knew the statutes and if I knew the legal statutes and what they said, which I said I've read them in the distant past, but I have not read them recently. I think my value as a court visitor in the reports I give to the judge are up to the judge to decide.
Okay, so that's good then. So, okay, I think we got it. Okay, now, do human beings, if everything's going right, generally progress? Meaning it's going to get better. In 2003, how old was Andrew Justin Clark?
I think he had just turned 18.
Okay, and how old is he now?
I would have to look at the document.
So you got some good familiarity with the case. Go ahead. It's probably in the investigation somewhere how old he is. Let me see if I can find it. Wait, I don't have the investigation. He was born on October 17th, 1985. That might help you.
Okay, well,
So there you go. Anyway, the point being is in that time where a man turns from 18 to 26, we would hope there'd be progress if everything's going right. And as that time I was guardian, so how in your opinion, as a court visitor who is very familiar with seeing cases like this, if I'm removed from guardian, do you see the situation that you saw necessarily getting better?
In investigating this case, I felt that this was a decision for the judge to make and not for me to make, whether removing you would be appropriate or inappropriate, helpful or not helpful. And my court visitor report was an attempt to provide the judge with the information that was currently involved with Andrew Justin Clark and where he lived and what he was doing, who he lived with, his siblings, and Matt Brownlee, who was the caretaker.
Is it correct that, it is correct me if I'm wrong, that you didn't even know his birthday until you went and looked in your records? At the most basic fact, you didn't even know.
You're right, I didn't remember his birthday.
And you unexpected to. Okay, but the point being is that's a very major fact. Now, you did an investigation. What other facts did you investigate? Remember, investigation is facts. What facts did your investigation show? I want to go through the facts that are relevant to the guardian.
My impression when I met with Amy Clark, Andrew Justin Clark, and his two siblings were that he has progressed tremendously from the first time that I saw him when he had turned just 18. He has progressed tremendously.
In a third of his life, is it not normal for a human to progress if things are going well? If the guardians are doing their job, and if the guardians are doing everything right, is it, in your opinion, normal then for someone to progress from the year 2003 to 2011? Normal?
In my experience working in mental health and with developmentally disabled adults in California, I didn't necessarily see such progression. In fact, I oftentimes saw that people either continued with their disability and their impairment, and so this I was very impressed with the way that he's progressed.
And did you see any evidence, were you presented in your investigations with evidence over all the years of his upbringing of the contributions of that time of Andrew Glenn Clark, me, in order to make it such that Andrew Justin Clark could continue that way? Noting again your experience in California, which we'll go into in a minute in great detail to see how it relates. Fragile X. Let's go through Fragile X. Are you familiar?
I'm going to interrupt you because it's now 12:25, and it appears that you're going to continue.
Oh, yeah.
So therefore, we will take a recess. We will reconvene at 1:30. We'll be in recess until then. You may step down.